Well, good morning for those of you in other time zones, and good afternoon to those of you in the Eastern time zone. I want to welcome everyone to our Labor, Employment, and Human Rights webinar entitled Employment Agreements and Termination Clauses, the Most Recent Developments in the Law. My name is Matt Link. I'm a partner in Fasken's Labor, Employment, and Human Rights Group. I'm based out of the Toronto office. My practice is dedicated to management side, labor, employment, and human rights law, which I've been doing for the better part of the last 2 decades. It includes defending employers in wrongful dismissal actions, human rights complaints, grievance arbitrations, certification applications, claims under the Employment Standards Act, Canada Labour Code, as well as other employment-related matters. Before I introduce my colleague and co-presenter, Felisha, I just want to draw your attention to this slide to see some administrative information on the screen, specifically drawing your attention to the survey and the CPD certificate points for those of you who are looking for CPD credits. QR codes and links are available at the end of the event to fill in our survey, and please do. And of course, also to obtain your CPD certificate for Ontario, Quebec, and British Columbia. As I indicated, joining me today, I'm pleased to have Felisha Jagiah, who is a colleague and an associate with me in our Toronto office. Felisha practices in all areas of labor, employment, and human rights law, and she's experienced in providing both private and public sector employers with practical advice on minimum employment standards, which we're going to be talking a whole lot about today, wrongful dismissal claims, grievances, and human rights complaints. And with that introduction, we've got a lot of material to get through today, so let's get started. In terms of a brief overview of the agenda, we'll start with unpacking the cause of all of the consternation that Ontario employers have had over the course of the past half decade, taking a look at the Employment Standards Act 2000, and then moving on to review the concept of the termination clause and why it is so important for you as an employer to be able to limit your liability on termination. The third section that we'll get to is recent developments in the case law as it relates to termination clauses in Ontario. And we're fortunate that there have been a number of important developments this year and issued decisions even very recently, which we're able to update you on as part of this session. And then finally, to close things out by providing an update on the case law as it relates to other areas of the employment contract. Again, whereas an employer, you may be exposed to liability on a termination without cause, and to provide you not only with an overview of the case law, a recent case law, but also some tips and best practice in terms of assisting you to be able to limit that liability. And with that, what I'll do is I'll turn it over to Felisha to tackle the Employment Standards Act 2000. Felisha.
Hello, everyone. Thank you for joining us today. As Matt said, we will be starting with a look at the Employment Standards Act 2000, or the ESA, which is the minimum employment standards legislation in Ontario. In order to understand an employer's obligations when terminating an employee in Ontario, they need to be familiar with their obligations under the Employment Standards Act. So it sets out minimum employment rights and entitlements to for most employees. So it's important to note that the ESA doesn't apply to all employees. And if you are unsure as to whether or not the ESA does apply to employees in your workforce, it's important to either turn to the Act or speak to a lawyer about whether or not your employees are entitled to some or the majority of the rights under the ESA. So that's a starting point. Does it apply? Another important aspect of the ESA is Section 5 of the ESA, which prohibits employers and employees from contracting out of or waiving employment standards that have been established by the ESA. So, for example, an employee may be entitled to termination pay upon the termination of their employment. And so Section 5 says that an employer and an employee cannot have an agreement that says that that employee is no longer entitled to that termination pay upon their termination. And if there is such an agreement, contracting out of the ESA, it is void. So now let's look at Section 54 of the ESA. What does this section say? So it's an important section because it tells us that an employer cannot terminate an employee who has been continuously employed with that employer for 3 months or more unless they provide notice, written notice of that termination, or they provide pay in lieu of notice. And more importantly, Section 55, and this is important to our presentation today, Section 55 says that this entitlement under Section 54, it doesn't exist for prescribed employees. We'll talk more about who prescribed employees are shortly. Section 64(1) is also important to become familiar with because it is on an employee's entitlement to severance pay at the time of termination. So in order to be eligible for severance pay at the time of termination, an employee has to be at a minimum entitled with, they had to have been employed with the employer for at least 5 years. And the employer has to have a payroll of $2.5 million or more. And that is a global number. So it's not limited to the employer's payroll in Ontario, for example. And Section 64(3), similar to Section 55, again, carves out this exception to this entitlement and says, okay, well, prescribed employees are not entitled to this severance pay. So again, who are prescribed employees? Well, the Act tells us under Regulation 288.01, termination and severance of employment, and it sets out which employees are not entitled to notice of termination or termination pay. So that's under Section 2. And under Section 9, it sets out which employees are not entitled to severance pay. And outside of these circumstances, or these employees, these employees who are entitled to terminations and severance pay under the ESA otherwise must receive their termination and severance pay. So let's look at what's carved out here, right? So if you look at Section 2, for example, you'll see a key circumstance that causes a lot of confusion. And so I'll focus in on that one. Which is that an employee who has been guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer is not entitled to their notice of termination or termination pay and their severance here. So, and that is the source of quite a bit of confusion, because when you look at the list under Section 2 and under Section 9, you'll see that, what you won't see is just cause written in there. So that is not an exception to the rule, which is that you must pay out termination and severance pay otherwise. So let's look at willful misconduct under the ESA. It's a very high standard to meet, and the key word here is willful. The misconduct must be intentional. It must be deliberate, purposeful. So it can't be, careless or spontaneous or an accident. It has to be done with intention. And so it's otherwise referred to as being bad on purpose. So if an employee is terminated for cause and it doesn't meet this definition of willful misconduct, so if they're terminated for a cause at common law, which Matt will talk more about shortly, then that employee must receive their minimum entitlements under the ESA. So going back to Section 54 and Section 63, I believe. So we have to go back to those sections to look at those entitlements. And so again, this is, what I was just speaking about. And so a key recent decision, is the Render and Theisenkrupp decision. And this is a case where an employer had a policy of zero tolerance for harassment in the workplace. And they had a long service employee who was terminated for cause for slapping a female coworker's buttocks. And this employee claimed that it was done accidentally. And so the employer found that this was serious misconduct and terminated for cause. And this employer did not pay out the ESA termination or severance pay. And so the court found that the slap was not accidental. And however, it was not pre-planned either. It was spontaneous. It was in the moment. And so this conduct did warrant dismissal for cause. So it was cause at common law. However, it was not the type of conduct in the circumstances in which it occurred that was intended by the legislature to deprive an employee of their statutory entitlements. So this was not a case of willful misconduct. So the court said in these circumstances, the employee was entitled to their termination and severance pay. Okay, and then I will now pass it back to Matt to cover the termination clause.
Thanks very much, Felisha, for that introduction. And I think what you've done is really laid out the framework in terms of, again, why are we here? Why is this thing called a termination clause so important? And again, as Felisha talked about in the context of the Employment Standards Act, if someone does not have, if the employee hasn't engaged in willful misconduct, they're entitled to a statutory notice of termination, pay in lieu, severance pay, if applicable. For those of you who may not be familiar with Ontario employment law, and frankly, really employment law across the jurisdictions and in the federal sector, what complicates things for Canadian employers is two different potential entitlements on termination that employees have, particularly in the event of a without cause termination. And perhaps the best way to think about it is you've got two buckets. There's the Employment Standards Act, or if you're in another province, or if you're a federally regulated employer, the The provincial employment standards legislation of that province or federally regulated employers, the Canada Labor Code. Legislation applies in that case to require an employer in engaging in a without cause termination to make certain minimal legal payments. And if you fail to do so, it's a breach of, it's a violation of the legislation. And there are avenues, mostly through the Ministry of Labor of the particular province or the federal jurisdiction, where an employee can pursue a claim for these payments. Separately, there is the concept of the common law. That is court-made, judge-made law. And in terms of the common law itself, the application is separate from the employment standards legislation. An employee can, if they feel they were wrongfully dismissed, commence a civil court action and claim reasonable notice of termination at common law. Importantly, where the termination clause comes into play, all that preamble is leading somewhere, is the significant differences in terms of potential liability that employers are exposed to when looking at obligations on termination of the employment standards legislation and the common law. In Ontario, again, your maximum, you're looking at 8 weeks of notice of termination or pay in lieu. If the employee is entitled to statutory severance pay, that's up to an additional 26 weeks. It's very different under the common law, where an employee is entitled to reasonable notice of termination. Or if you can't provide reasonable notice of termination, pay in lieu. And we don't need to go into the test of how courts determine reasonable notice of calculation. That's for a whole other seminar. But essentially, what a court asks itself is based on an individual's circumstances. So their length of service, their age, the type of position, whether it's a manager or supervisory position or not, sometimes the economic circumstances. How long would it take this particular individual to secure new comparable employment? And we use the word ballpark of 1 month per year of service because the courts have repeatedly said there is no such fixed item or fixed time period for a formula per year of service. The only thing we can count on is that there is a general maximum reasonable notice of termination at 24 months. And again, there are also exceptions to that, which we won't get into. So again, you can see why an employer would want to limit entitlement to just the employment standards minimums, or perhaps something slightly more than that, but less than the common law. And where this then brings us, again, is the concept of the termination clause. To use a termination clause in an employment agreement to contract out of common law notice or to cap an employee's entitlement on a termination to only that the employer's legally required to provide under employment standards legislation. Where all the trouble has come into place is bullet point number 2. The employer cannot provide less than minimum standards or contract out of minimum standards protections. If they do, the clause is void, and the employee is, again, not only entitled to the minimum employment standards, but they're also entitled to, again, bring that claim for common law reasonable notice of termination. And so the upside for them is potentially far more significant. There are a number of areas where employers run into trouble. And that includes a definition of cause in the employment agreement that doesn't comply with the ESA, which we'll review more shortly, and then failing to specify in the termination clause that all entitlements will be continued to be provided during the statutory notice period. And when these sorts of wrongful dismissal decisions challenging termination clauses started arising in the early 2010s, the focus of the area of invalidity for a termination clause was on the employer, at least in Ontario, neglecting to reference the fact that an employee on a termination was entitled to all of their entitlements under the ESA, not just pay in lieu of reasonable notice, or sorry, pay in lieu of notice of termination or termination pay under the ESA, but also statutory severance pay and also benefit continuance. And what we saw through the 2010s is a lot of litigation on employers failing to specify all of those entitlements. This area of the law, again, has been around for a long time. And this is sort of the granddaddy of the contracting out of the common law of reasonable notice case, a case called Machtinger, where an employer, the Supreme Court of Canada held that an employer can displace and rebut the implied obligation to provide common law and reasonable notice in the event that an employee is terminated without cause, that it's permissible to limit their entitlement to only the minimum payments under employment standards legislation. I want you to focus for a moment on the displacement of the implied obligation to provide. That's really important. The default is providing common law notice. And so the way courts approach is you can take that away from an employee, but if you're going to take something away, you got to do it properly. As we'll see in a moment, it really comes down to almost making sure that every I is dotted and every T is crossed. Termination provisions that don't meet the employment standards minimums at the time of termination are void. And this is critically important as well. The same is true if the termination provision could, at any given point in time, violate employment standards minimums. So, for example, you could have a termination provision that says that, again, the employee may be entitled to 2 weeks' notice or pay in lieu of notice per completed year of service. You may have one that says 1 week. At the end of the day, you could have a situation where a termination provision might be enforceable at a certain point in time during the employment relationship. But if in the future it could be found to be invalid because the cap on the notice or the pay in lieu of notice that you're providing is less than employment standards minimum, then the provision is void. We've included this. I talked about these the termination clause litigation cases sort of started in and around the early 2000s. Wright, Young, and Rubicam is one of them. At this point in time, we were more concerned with referencing the word severance pay and benefit continuance in our termination clauses. And boy, oh boy, I don't think the particular court in question here really necessarily thought where things would go 10 years later. It's quite the statement to say, again, from the judge at this point in time, there is, in my view, no particular difficulty in fashioning a termination clause that doesn't violate either the minimum standards imposed by the Employment Standards Act or the prohibition against waiving statutory minimum requirements. And there's no compelling reason to uphold a termination clause which the draftsman may reasonably understood to have known was not enforceable either at all or under certain circumstances. Boy, oh boy, no problem at all in terms of fashioning such a clause, particularly one that one would have thought was enforceable. Things changed, as you will know. I think that sort of if you're in the employer or management side council community, you would, I think, see Waxdale and Swegan North America as essentially sort of an earthquake or a sea change, as they say, when it comes to the law in terms of enforceability of termination clauses that limit entitlement to ESA only amounts. And again, we won't go through the whole case other than to essentially point out that where Waxdale sort of changed the game is the fact that the focus was on the failure to distinguish between common law cause, so cause at common law, versus cause as defined in the ESA regulations, which is willful misconduct. And Felisha referred to that difference in the Render and Tyson-Kripp decision. There is a significant difference. Willful misconduct is a much higher standard than simple cause at common law. And the court held that if your termination provision references cause, but you're not, and says there's no entitlement to any notice of termination, pay in lieu or otherwise, but you're not making a distinction between cause at common law and willful misconduct, that ambiguity is likely going to be found in the favor of the employee. It's going to be found that clause violates the Employment Standards Act, and so the entire clause itself going to held to be unenforceable. And that puts us back into the common law notice realm. So this was a big shocker. I still remember this. It was during the summer of 2000. It was during the pandemic. I was at home, as everyone was, and we got this decision came across, and we had to pull our jaws off the table. It was unbelievable. And then we thought, okay, well, that's fine. We get it. We'll just fashion clauses that make that distinction between just cause at common law and willful misconduct. Well, not so fast. Because in the intervening 5 years, of course, when you have a decision like that, the court then further extrapolates and expands on the law. And so what we had, for example, in 2022, in a decision of Henderson and Slavkin, is the court in that case looked beyond the termination clause itself at other provisions in the employment agreement, in particular a conflict of interest clause and a confidential information clause. And it found that because those clauses were unlawful, that had the effect of rendering the termination clause unenforceable as well. And then finally, and again, I say this with all respect, from a management side employment law council point of view, we reached peak insanity with the trial level decision in Defoe and Ignace Township in 2023, 2024, where a lower court found that the simple inclusion of the term at any time as a qualifier to an employer being entitled to terminate employing at any time, or at their sole discretion, in itself invalidated the termination clause, because it found that there were situations, and this is true, there are situations where an employer is not able to terminate an employee's employment at their sole discretion at any time. For example, if they're on a job protected leave under the Employment Standards Act. This decision was appealed to the Court of Appeal. The Court of Appeal did not deal with the anytime or sole discretion pieces, but it did uphold the lower court decision, finding the termination clause to be invalid on the basis of an invalid for cause provision. And so, look, I'm going to be frank with you. Going into 2025, things are pretty grim for employer side counsel. I remember having conversations with colleagues and mediators, and we thought, boy, where are we going to go next? We're going to now look at employee handbooks, for example, to see where a particular provision with respect to privacy or confidentiality at page 675, if that's unlawful, does that then invalidate the termination clause in the employment agreement? So it was difficult and certainly difficult, again, as counsel, like Felisha and I, to provide our employer clients with a significant degree of assurance as to what kind of language you could actually include in an employment agreement that would render a minimum employment standards clause enforceable on termination. And with that, I'm going to turn it over to Felisha to give you some good news in that, as we said in our opening description, perhaps the pendulum is starting to move a little bit more towards the center again. So, Felisha?
Thank you, Matt. So we will now be looking at recent developments in the case law, and we have provided a diagram here that sort of sets out which cases are or appear to be employee friendly, employer friendly. So those are cases where either the language was found, the termination language was found to be enforceable, or the court found that the presence of at any time in the termination language was not, it does not automatically render the termination clause to be unenforceable. We have a case on layoff provisions, terms and conditions, and then notable cases. So this is just at a very high level what the recent developments are. So the first case that we'll look at is the Baker and Van Dolder's Home Team Inc. decision. So this is a case that it's the first case, to follow and cite Dufo. And so again, as a reminder, Dufo, as Matt just mentioned, in Dufo, the court found that the termination clause was unenforceable because it had both at any time and it had sole discretion, right? The employer could terminate at any time at its sole discretion. That was contracting out essentially of the ESA. In this case, in Baker, the sole discretion language was not present. It was just the at any time language in this case. And the court invalidated the without cause termination language solely because it contained reference to the termination at any time. And the court essentially said it could not find reason to depart from the decision in Dufo. So, following this decision, it seemed that the prudent approach was then to assume that any provision containing reference to termination at any time, even if sole discretion is absent from the termination language, the termination clause would be unenforceable. That was our understanding after this case. Now, then we get Jones. Jones and Strides Toronto, which is a nice case. It is an employer-friendly case. And so this case was issued in April of this year. And interestingly, the court reached a decision opposite to what the court reached in Baker. And so again, this is a case where there was at any time language, but the court clarified in this case that Dufault does not stand for the proposition that the words at any time, separate from sole discretion, which both of those phrases were included in the Dufault language, are improper in an employment contract. So the court found that the presence of at any time in the termination language did not bring it into conflict with the ESA. However, in this case, the termination clause was found to be invalidated, but on other grounds, in the end, it could be read as not requiring the continuation of benefits during the statutory notice period, which is contrary to the ESA and an employee's entitlements upon termination. But this was a good case. And so then we get Lee and Wayfair Canada Inc., another great case. So in this case, again, we have a with cause provision that contains the at any time language. And in this case, the court said this at any time language does not automatically render the termination clause unenforceable. So now we're building on Jones. So on one side, we've got Dufault. Well, I mean, interestingly, you've got Dufault at the top, which is that the termination language is unenforceable because it has both at sole discretion and it has at any time. Then you've got Baker on one side that just has at any time language, and that's unenforceable, says the court. Then on the other side, you've got Jones and Lee, both of which have just at any time. Court says they're enforceable. Or that it doesn't render the termination clause unenforceable. So we've got two sides here. We've got one, Dufault's at the top. So now let's move on to the next case. Let's just keep going. So here now we've got Chan. So this one takes us back to, the other side of things. This one is not employer friendly. So in this case, the court found that the termination provisions were void and unenforceable for various reasons, one of which was that the employment agreement purported to allow for termination at any time without cause. And so Dufault is cited and Baker. So we've kind of got, an addition to this side of things. And the court, interestingly, did not cite or engage with Jones and Lee, which were on the other side. So unfortunately, just as we thought that there was some sort of clarity on this issue of at any time language, we now have this Chan decision. This was a case where the court reviewed the termination provision of an employee who had been terminated one day prior to the expiration of their probationary period. Not a great case, not a helpful one. At this point, we're anticipating that one or all of Jones, Chan, or Lee will be appealed. Baker, perhaps, and it needs to be addressed at the Ontario Court of Appeal because as it stands, it's unclear as to whether the presence of the right to terminate at any time in an employment agreement, even without the sole discretion language in and of itself, will invalidate the termination language. So moving forward, employers, they should continue to be very careful in how they're drafting their employment agreements, and still exercise some caution around the use of the at any time language. And then I want to flip to a case that is an employer-friendly case, and we'll end this section on a positive note. Matt mentioned that the Waxdale case was like an earthquake, and things had not been great since then. But now we have the Birch decision and Data Stealth Inc. And this was for the first time since Waxdale, we had a case where the Ontario Court of Justice, Superior Court of Justice, upheld a termination provision that limited an employee's termination entitlements to their minimum entitlements owed under the ESA. And so we've included here the language that was found to be enforceable. So this was great. This was a case about an employee who had about 8.5 months of service. And at the time that their employment came to an end without cause, they were provided with 4 weeks pay in lieu of notice, which was greater than their ESA entitlements at the time. The court reviewed the termination language in the contract and decided in favor of the employer. And this was this language complied with the ESA, and there was no reasonable alternative interpretation of this provision that may result in an illegal outcome. So it wouldn't be contrary to the ESA. So this language here, the court has identified as being clear and unambiguous. And this was a decision that was appealed, and it was affirmed by the Ontario Court of Appeal in May of this year. So it's a great case. And so the Court of Appeal found that the issue is not whether an ordinary person might look at a termination clause and arrive at an incorrect interpretation. Incorrect meaning, that the termination clause is attempting to contract out of the ESA and the employee's entitlements pursuant to the ESA and upon termination. But rather, the focus is on how the agreement can be reasonably interpreted. It's nice to have a case like this in the sense that it signals that, that the courts are still willing to uphold ESA minimum termination language, and they won't strain to find ambiguity in every scenario. So it's a nice case to have. And on that note, I will pass things back to Matt to cover some of the other decisions that I noted at the beginning of this part of our presentation, and let's talk about some cases beyond the termination clause.
Yeah, and I think Felisha I think it's an understatement to say that Birch and Data Stealth had some very helpful reasoning, and certainly when that decision was issued, you obviously, I think, probably heard a number of cheers from the management side bar with respect to that decision. And, again, finally having some sense of certainty as to the kind of language that needed to be present in a termination clause, a minimum employment standards termination clause, for the employer to enforce it. And again, as management side employment law counsel, pleased to advise that the good news seems to be continuing as we head into the fall of 2025 into other areas of the employment agreement beyond the termination clause itself. For those of you who were employers during the pandemic and had to lay off employees as a result of a slowdown in business or the closure of the business again. And if the decision was not saved by a number of the emergency regulations that were brought into force at the time, And ultimately, that you had to lay that person off and wanted to rely on, for example, the ability to temporarily lay off an employee for either 13 out of 20 weeks or 35 out of 52 weeks, provided that benefits are continued, as is allowed for under the Employment Standards Act, without triggering a termination of employment. What we found again a couple of years ago coming out of the pandemic is that increasingly employees were challenging the decision to temporarily lay off an employee. And this was, it was confounding, I think, for many employers. They thought, boy, I've got my ESA here. I'm on the Ministry of Labor website. It says that I can temporarily lay off someone for 13 weeks out of 20 or 35 out of 52. And as long as I recall them within that time period, employment isn't terminated. And they then got a demand letter or they got a statement of claim from the employee saying, well, actually, you've constructively dismissed me. And the argument there, and this was accepted by Ontario courts, is that if an employment agreement does not contain a separate provision that wherein the employee agrees that a temporary layoff in compliance with the Employment Standards Act does not constitute a constructive dismissal, entitling them to reasonable notice of termination. If you don't allow for the ability to temporarily lay off employee under the employment agreement, it could be a constructive dismissal. And again, a constructive dismissal is a wrongful dismissal, is a without cause termination entitling the employee to reasonable notice of termination. And so we saw a number of those cases, and of course, have pivoted in the last number of years. If you have not in your when you're updating your employment agreements, included a specific clause to allow for a temporary layoff, and expressly state that it doesn't constitute a constructive dismissal, you're advised to add that to your contract. And so employers started doing that. And of course, every time as an employer you pivot, well, then employee side counsel will try to find some other way to undermine or invalidate your provision. And that's what happened in Taylor and Solidix, a case that was issued just in the last couple of months. It dealt with a layoff provision where the ability to temporarily lay someone off in accordance with the ESA was unfortunately not contained in a separate clause, but was included under the termination heading. So the placement was very, very unfortunate, and plaintiff's counsel seized on that. The parties both agreed that, at least insofar as the for-cause portion of the termination clause itself, that the termination clause was unenforceable. They agreed that it didn't comply with, it didn't make that distinction in terms of willful misconduct or just cause, or just remain silent on it, as the enforceable clause in Birch and Datacell did. And so the plaintiff argued that because the termination clause was unenforceable, the fact that you had this employee layoff provision in that clause invalidated it. Again, fortunately for employers, the court held that the placement of a contractual provision, in this case under the heading termination, is not determinative of whether it is a termination clause or not, and accepted the employer's argument in this case that a layoff is only a termination when there is no clause in the agreement permitting the employer to lay off the employee. So it is a term. So again, a layoff can be a termination if the employment agreement doesn't allow for it. But in this case, the employment agreement allowed for it. And therefore, the court held that the layoff was not a constructive dismissal and was not a termination. And so ultimately did not accept the plaintiff's argument in that case. The good news for employers as it relates to the enforceability of contractual clauses outside of the standard termination clause continued in the Wigdor and Facebook Canada decision. You see, this is just really it's only just 2 months old. And again, another, I talked about sort of Waxdale being kind of a sea change earthquake decision. This Wigdor and Facebook, we assume that it's going to be appealed, and if it's upheld on appeal, could be a game changer in favor of employers as well. And what this decision, amongst the things that it dealt with, but for purposes of this presentation, the important piece that it dealt with was entitlements under a restricted share unit agreement. And again, as employers, you may be aware that separate from termination clauses, when it comes to entitlements to compensation over the reasonable notice period, that there's been a lot of case law that has come out with respect to things other than salary: bonuses, commissions, deferred profit sharing, restricted share units. And there's pretty solid and developed case law, for example, in areas such as bonuses that goes back a couple of years now, where if you do not have language in your employment agreement or in a bonus plan itself that says on termination of employment, the employee's entitlement to continue to participate in that bonus plan, for example, or that commission plan, is limited to what's required under the Employment Standards Act, the number of court of appeal decisions to say, well, then they get to participate for the full common law notice period. And that, depending on the individual's compensation plan, can be a significant portion of their total compensation package and can result in hundreds of thousands or even millions of dollars in sort of extra compensation that the employer had to pay out. And so that's what made Wigdor and Facebook Canada, I think, so interesting. In that case, it dealt, like I said, specifically with a restricted share unit agreement. And again, this is one case. It's dealing with specific language in this specific RSU agreement, and the case has yet to be appealed. So we put all those caveats on top first, but then get down to it and say that, look, in this case, the language in the RSU agreement, which provided that entitlement terminated vesting immediately on termination, is important, without regard to the statutory notice period. doesn't violate the ESA and is enforceable. Now, this is remarkable, right? Because we talked earlier with respect to even going back to the beginning of our session, the key is to continue everything during the statutory notice period. And if you're leaving some of that out, if you're leaving the entitlement to severance pay, if you're leaving out benefit continuance, that violates the ESA, violates the termination clause. So here your court's saying, well, with this respect to this RSU agreement, where you can terminate it, vesting on termination, and you don't need to include the statutory notice period, that doesn't violate the ESA. Pretty shocking. But counsel in this case drew, of course, the court's attention to the differences in language between certain sections of the Employment Standards Act. Section 60, where pay in lieu of notice is provided, 61, where pay in lieu of notice is provided, with Section 60, which requires employers to maintain all terms and conditions of employment during the statutory notice period. And I won't read through this whole thing, but it's worth, opening up your ESA or going on the Ministry of Labor website and looking at the differences in terms of language between a situation where you're providing notice of termination, that's statutory notice period, where you're continuing all those entitlements during the notice period, and 61, where you're terminating employment immediately or with less notice than is required under the Act, and so you're having to provide pay instead of notice. And the distinction that the court ends up making is it says there is a difference between Section 60 and Section 61. Under Section 61, where you're terminating employment and providing termination pay, yes, you have to continue to make benefit plan contributions, and you have to continue to pay the employee the amount they would have been entitled to based on regular wages. This is the important piece. Regular wages, and regular wages was determined to not include restricted share units. In this case, the restricted share units were governed under a separate agreement. And again, they were not regular wages. And so, because the employer only had to pay the employee termination pay based on regular wages, and RSUs aren't regular wages, the fact that they terminated the RSU entitlement immediately on termination, rather than allowing vesting to continue to accrue during the statutory notice period, was not fatal to that provision. Again, I put a big caveat next to this, which is that we do anticipate this is going to be appealed, and like with a number of a number of the sort of conflicting good news, bad news, depending on which side of the fence you sit on, cases that Felisha talked about, ultimately these cases and these decisions and the principles that come out of them will likely need to advance on to the Ontario Court of Appeal for a more definitive conclusion. One final, what we call noteworthy case, which we just raise again, just very, very recent decision because it raises what we call a novel argument. We talked earlier about the ways in which, after Waxdale was issued, the ways in which courts accepted claims from plaintiffs and plaintiffs' counsel to look at other areas of the employment agreement with a view to potentially invalidating the termination clause. And so, for example, a provision that says that it's just cause if you violate the confidentiality provision in the employment agreement and you're not entitled to notice or pay in lieu of notice. Well, because in that case, we saw because you just referenced just cause and no entitlement, and didn't make that distinction with respect to willful misconduct, that ultimately serves to invalidate that provision and then dovetails back to invalidate the termination clause itself. Well, in Timmins and Artisan Cells, plaintiff counsel similarly tried to make a novel argument to invalidate the termination clause. And this is interesting because I think if you look at, I don't know, 99% of employment agreements in the province of Ontario, maybe 95, I don't know, the vast majority of them, there will be an exclusive jurisdiction clause, usually way at the end of the agreement under the general terms and conditions provision. And it says that, look, that again, if there is an issue with respect to the employment agreement, its breach, then that dispute must be resolved under the exclusive jurisdiction of Ontario courts. So Ontario law, Ontario courts. And what the plaintiff in this case argued, they said, well, that's actually an illegal clause, because by saying that any and all disputes with respect to the employment relationship or the employment agreement must be dealt with by Ontario courts, that necessarily means that you are prohibiting the employee from bringing, for example, an unpaid wages complaint or a vacation pay complaint or a termination and severance pay complaint via the Ministry of Labor. And which is, again, that's an employee's statutory right to be able to do that. And so they argued that this exclusive jurisdiction clause, again, was illegal, and that should serve to invalidate the termination clause. Again, fortunately, from the employer side of the bar, the court did not accept that argument. It didn't accept that argument, and so found, look, we're not going to invalidate the clause just on this novel point alone. Just a couple of best practices, which I think, hopefully you get a sense of during the course of, the past 65 minutes or so. We have come across to you without saying it. We're going to now just say it in terms of best practices for drafting enforceable termination clauses. Obviously, clear and unambiguous. I think what you'll find if you take a look at termination clauses in employment agreements in the province of Ontario, for example, dating back to, if you've got employment agreement precedents dating back to, say, 2007, 2008, 2009, 2015, I suspect that what you'll find is that the termination clause, particularly since Waxdale in 2020, has grown shorter and shorter. It used to be the approach was to make it exhaustive to define each and every situation that could constitute cause. But these termination clauses are almost impossible for an employee, a layperson, to read or understand, much less a court. And so that's why you see we're pivoting, and we saw this in the Birch and Data Stealth decision, to a very, very simple termination clause because it's clearer and it provides for less room for ambiguity. I know as an employer, again, we want to be able to sort of focus on, well, you know what, in a situation of for cause, these are all the things that can be caused, and you're not going to get termination pay. Well, the court's been clear that that is not going to help you. So a simple, clear, unambiguous clause is your best friend. What you may want to consider as well in terms of situations, confirming that again, with respect to notice of termination, that you're not limited to either just providing notice, that you could provide pay in lieu, or that you could provide a combination of both. Consider whether or not, and this is more so, again, for more senior or management employees who may push back on a minimum employment standards termination clause, is to provide for something more than that. Ensure, of course, that the employment standards minimums are included and are covered, but offer something more, whether it's a flat amount or a formula that grows over time. And anecdotally, I think what we find as well is that look, if you go back to the Supreme Court of Canada, a decision in Machtinger, common law notice of termination, that's the default entitlement. And courts may not say it, but I think sort of some at the trial level are reluctant to disentitle someone to reasonable notice of termination, particularly someone, with a lengthy period of service. Say you've got 35 years service, you're 65 years old. That's a slam dunk 24 months notice, and as part of a wrongful dismissal claim. And if a minimum employment standards termination clause is enforced, that reduces it to 34 weeks. Huge difference. And so consider whether offering something more than that not only makes sense in terms of, for good business sense and something that your employee will appreciate, but it may be that the court looks at that favorably and may be more inclined to enforce it. Think about as to whether or not you want to include a lump sum or a salary continuance provision. We talked about the calculation of payments, benefit continuance, and mitigation. So these are all things to keep in mind. Again, look, ensuring that whatever form your clause takes, and like we said, the simpler, the better. If you are inclined to use a more expansive clause and you want to limit the employee to their entitlements under the Employment Standards Act only, then you've got to include all those enumerated components, right? You get your notice, you get your pay in lieu of notice, benefit continuance, severance pay, earned wages, unpaid up to the date of termination, earned and unused vacation pay, and vacation pay on termination pay, right? And that's an entitlement under the ESA. So make sure to not leave out any of those entitlements. And although the courts have said that a saving provision is ultimately not going to be able to rehabilitate or cause to be an enforceable and otherwise void termination clause, including such a clause in there still is good practice. Again, just a general statement ultimately that in no situation will the employee be entitled to anything less than their statutory minimum entitlements. And then finally, again, if you're so inclined, and this is, I mean, particularly for more senior employees, if you're wanting to offer something more than employment standards minimums, consider whether adding the requirement that they sign a full and final release of claims in exchange for that additional payment should be included. That may not be prudent in all cases because the employee may say, well, I'm not interested in signing full and final release. So it really sort of depends on the circumstances. And with that, I think we've got about 15 minutes or so for questions. And I think what we, as Felisha and I talked about before our session today, typically, unfortunately, when you're getting through these many cases, you often run out of time. And so what we purposefully did was perhaps pruned some of the case law discussion a little bit to leave some time for questions, because we received some really good questions in advance of the session. And I see, oh gosh, 24 questions now over the chat as well. So we're not going to be able to answer all of them, but hopefully we'll be able to answer more than the 2 or 3 that we usually are when we only have 5 minutes left. Maybe what I'll do is I'll start with a question about other jurisdictions. And specifically, I know the focus of the session today was with respect to Ontario, because frankly, that is where most of the case law development is. And that is the only place that you have in terms of, for provincially regulated employers, employment standards legislation across the country that has that pesky willful misconduct distinction. You don't have that distinction from just cause in other provinces. That being said, that doesn't mean that other provinces don't have their issues, quirks, and challenges. And I think what I'll do is start off with this great question from, I think, an attendee from Quebec, or perhaps they're just asking a question about Quebec. He says, to clarify whether these decisions affect the law in Quebec. It's a great question, and the simple answer is no. Quebec is, and again, for provincially regulated employers, is separate for federally regulated employers who are, irrespective of the province in which the employee is in, you're subject to the Canada Labour Code. For provincially regulated employees, subject to the Act respecting labor standards. Quebec is a civil code jurisdiction as opposed to a common law jurisdiction, so all the other provinces. And so an employee is not able to bind themselves to a minimum employment standards termination clause when they sign an employment agreement. That decision has to be made in terms of their entitlement when the employment relationship is terminated. And so, unfortunately, none of what you heard today is going to be helpful. I hope you found it interesting. But I think the takeaway is, insofar as employment law is concerned, Quebec is an entirely separate and different beast, and to tread carefully. And certainly, as I say to clients with operations in Quebec, yet just because you got to put a termination clause in there doesn't mean that it's going to be enforceable. So be live to that. If you have provincially regulated employees in Quebec, this ability to limit entitlement to statutory termination pay only is not going to exist. In terms of other provinces, please address how this relates to BC, if at all. I'll say this. If you have employees in the province of British Columbia, congratulations. You have far fewer hills and potholes to navigate when it comes to termination clauses. It is somewhat ironic, I think, that BC courts, because the BC Employment Standards Act doesn't have that same challenge for employers as Ontario does, it references cause for termination, no willful conduct, misconduct distinction. BC courts, up to and including the BC Court of Appeal level, have repeatedly upheld basic minimum employment standards, termination clauses that say you're terminated for cause, you're not entitled to a notice or pay in lieu of notice. If you're terminated without cause, your entitlements will be limited to those under BC Employment Standards Act. Those clauses have been upheld, and that's great news. In terms of developments in other provinces, again, you want to look at the province in which you have employees. Alberta, I would just generally say, is sort of somewhere in between. There's some finickiness in terms of the Alberta Employment Standards Code that requires certain language to be there in order for the clause to be enforceable. But I think sort of the takeaway for you is that unfortunately, when it comes to employment law, Canada is not a monolith. And although it would obviously be easier, cheaper, more efficient, less of a headache for everyone to have a single one-size-fits-all employment agreement, something that says, you'll be entitled to whatever your entitlements are under the employment standards legislation of the jurisdiction in which your employee works or resides. Not to say it's not worth the paper it's written on, but certainly, again, in Ontario and other provinces, it's not going to assist you. The better approach is to draft province-specific employment contracts. So let's see. We've got a couple. Gosh, we've got so many questions now. Oh, this is a really good one. Felisha, you talk a little bit about termination of employment while on probation. And, we talked about termination clauses and where that might factor in.
So, in terms of probation or probationary clauses, generally, I don't think that they're necessary. I would turn my mind to the purpose of that sort of clause. Because in Ontario, and generally people tend to set their probationary period to about three months. And in Ontario, if an employee is employed for less than 3 months, they're not entitled to termination pay and certainly not severance pay. So if the idea is to limit their entitlements so that if they're terminated at the 2-month mark of their employment, for example, they get nothing. You don't necessarily need a separate clause to do that. You can do that within your termination clause, whatever that may be. So let's say, your plan is to provide only this employee's entitlements pursuant to the ESA when their employment comes to an end. You don't need to carve out a separate clause for their probationary period. You can just put that into the termination clause and that will apply from start to end. So I don't think that it's necessary in that case. And if anything, I think it's risky to try and craft another clause in relation to termination. Keep it simple and go with just the one. If you want to go with a formula instead, I think perhaps the right way to go about it is to have your formula and then have that language in there that, otherwise the employee will receive whatever their entitlements are pursuant to the ESA. And that's just, I'm paraphrasing here, but that's essentially the gist of what that clause would say. So again, I don't think that it's worth it to really explore a probationary clause. I think it's asking for trouble there. So I would leave it out.
Yeah, I think that's right. And again, this is when I've had discussions with clients about this as well, and I may understand conceptually this idea, but again, simpler is better. The more language you include, the more area there is for invalidity. We've got so many great questions. Okay. If we terminated a fixed term contract, do we still have to pay the entire balance if we terminated it before the end of the term? Oh boy. Yeah, that is a great question. Again, and we're talking about Ontario here. Look, a properly drafted fixed term contract with an early termination clause that complies with the Employment Standards Act means you don't have to pay out the entire balance. The challenge, though, and you just need to Google this, is you will see in the last 5 years some really remarkable decisions where, first of all, employers entered into really lengthy fixed term contracts, like a 5-year fixed term contract or a 7-year fixed term contract. My first advice is, like, if you can, don't enter into a fixed term contract that's longer than a year. Because then if you have to terminate early, you're limiting your potential obligations on termination. And again, as employers, it's always a challenge, right? On the front end, you're excited about, you're wanting to attract an exciting candidate who's going to help your business, who's going to succeed, who's got wonderful references, and you want to lock them down to a fixed term, and so you agree, because a fixed term, again, of 3 or 5 or 7 years provides that individual with certainty as well. And then 6 months in, it turns out that things don't go so well. And there are a number of published decisions out there, again, over the last couple of years, where if you don't expressly include the ability to terminate the fixed term contract early and provide for something less than the remainder of the term, or if the termination clause where you try to terminate early and that clause is invalid, then the damages the employee suffers is the remainder of the term. And you'll have to pay out the remainder of the term. And famously, there's a case from a couple of years ago where it was a 5-year fixed term contract, and the employer terminated it 17 months in. And they had to pay the remaining 3.5 years, which was $2.5 million. Importantly as well, and we didn't get into this, but this is an important distinction. I'm glad this question was raised with fixed term contracts, is that for an indefinite term employment agreement, employees entitled to, again, assuming you don't have an enforceable termination clause, the employee is entitled to reasonable notice of termination. That's subject to mitigation, right? You have to make reasonable efforts to find another job. And if you find another job during the reasonable notice period, then that serves to reduce what the employer has to pay. Well, the Court of Appeal has said that with a fixed term contract, mitigation does not apply. I mean, so it's a double win. for employers? So that's a great question. What I say is, don't avoid fixed term contracts altogether, but keep them as short as you can to limit the potential downside if things go awry. Next question. Okay, Felisha. Does this apply only to employers with a head office in Ontario, or also to employees in Ontario who have an employer who's based outside of Ontario, like in Quebec, like in British Columbia?
So I take it that this is the Employment Standards Act, and I understand that we're talking about the employees' rights here, right?
Yes.
So when it comes to the Employment Standards Act and who it applies to, we're not looking at the employer. So the employer could be based in Quebec, it could be based in Vancouver. That's not what we're looking at. We're looking at where this employee resides and performs the majority of their work. So if an employee is living and performing their work in Ontario, even if, let's say, they travel for a weekend to New Brunswick to continue some of that work and then come back to Ontario, that the ESA does apply to that individual, assuming that they're not excluded under the regulations, for example. So that's what you're really looking at. Where does your employee perform that work?
Excellent. Well, I'm going to try and get through two questions in 2 minutes if I can. Is benefit continuation required if pay in lieu of notice is provided? Yes, in Ontario it is. And one thing I like to highlight as well is its continuation of all benefits. Be very careful in terms of, again, most employers will provide some form of group health benefits coverage that is either adjudicated or partly insured by a third party insurer like Canada Life, Great West Life, Sun Life. And make sure that your benefits contracts allows for all benefits to at least continue during the statutory notice period. I'm still finding situations where the employer is only under the term of contract able to continue, for example, extended health and dental, and where life and LTD coverage terminates on termination. That's illegal. That is contracting out of the ESA. And your insurer will be live to this. And you should be able to negotiate a plan that makes it very clear that all benefits continue during the statutory notice period. It's a whole other question about whether you want to continue them or whether you can continue them through the common law notice period. That is for another day. And then lastly, is it better to include a termination clause in an offer letter or leave it out altogether to avoid nullifying the whole agreement? Well, if you don't include a termination clause in the employment agreement in the first place, well, you're going to default to the common law anyway. And maybe what the asker of this question was asking is something like, for example, if I reference a termination clause in my employee handbook instead of the employment agreement, would that be better? Answer is no. It's got to be in the employment agreement. And so if you're wanting to limit entitlement on termination to something less than reasonable notice of common law, include that in your employment agreement. Make sure it is clear, concise, unambiguous. And with that, that brings us to the end of our presentation. Just such great questions once again. I'm so sorry we couldn't get to as many as we had hoped to. there's only a limited amount of time. But I want to thank everyone online for joining us today. Again, you'll see on your screen there with respect to CPD credits for Ontario, BC, and Quebec. Links have been included for the audience chat. Please take a survey. Felisha and I would love to hear from you about the presentation in terms of, I'm sure, this session is going to be repeated again, whether it's next year or the year after. There will be developments in this area. Happy to hear from you about ways we can improve it. Our next LEHR webinar will be held in October. Please keep an eye for the invite in your invitation. And once again, to everyone online for sharing the last 90 minutes with us, really appreciate your time and have a great rest of the afternoon.